Let's now move on to fiduciary duties in the partnership. None of this should be very unfamiliar to you. Largely the same doctrines we have discussed when we discussed fiduciary duties in the corporation. We have the duty of care of partners. We have the duty of loyalty of partners. We'll talk about the partner's duty not to compete with the partnership. That's not something we discussed a lot when we talked about fiduciary duties in corporations, and we'll talk about the duty of good faith of partners. The duty of loyalty, once again, same issues that we saw when we discussed the duty of loyalty in the context of the corporation. We have the conflict of interest, we have self-dealing, kickbacks, and then instead of corporate opportunity, we have partnership opportunity or usurping a business opportunity. Let's talk about the partnership duty of care. Remember the duty of care in the corporation, right? It's good to look back and then compare, and that way you'll learn the law better. Duty of care of directors and officers in the corporation. They will be liable only if they engage in a grossly negligent or reckless decision-making process. So we go to the partnership. Is the standard the same? It really depends on the jurisdiction, but if you look at the Revised Uniform Partnership Act, Section 404C, it seems to indicate that the duty of care for partners is the same that we discussed for the duty of care of directors or executive officers in the corporation. Grossly negligent or reckless conduct. Once again, focusing on the decision-making process and not the decision itself. Let's talk about partnership self-dealing. What about fairness review? Remember, if you're engaged in some sort of duty of loyalty issue, you can escape liability by showing that the transaction was fair to the corporation if you're a director, or you can show that it was ratified by disinterested, independent directors or shareholders after you fully inform them about the transaction. So what about fairness review in the case where we have a partner that engages in self-dealing or has some other conflict of interest with the partnership? Well, probably not. I don't think there's a lot of support out there in treatises, secondary sources, or in case law that a partner can escape liability from self-dealing with the partnership, a duty of loyalty claim, if she shows fairness. It probably is not the law. But what about ratification? What if the other directors, either before the transaction, not directors, what if the other partners, either before or after the transaction, approve the transaction, knowing that I was conflicted and after I gave full disclosure about all the other material aspects of the transaction? Well, because this would be considered an extraordinary transaction, we probably need approval of all the partners. So ratification in the partnership, yes, it will probably work, but we probably need ratification of all of the partners. We need approval from all of the partners. You can change this in the partnership agreement, and indeed a lot of partnership agreements do change this. They say, listen, if they're self-dealing, that will be okay as long as it's approved by a majority of the disinterested partners. What about partnership opportunity? We have a partner that takes a business opportunity for herself, and one of the other partners say, hey, you should have given that opportunity to the partnership. Well, what about fairness? Yeah, probably. I think the partner, if the partner says, you know, it was fair for me to take the opportunity and not give it to the partnership, yes, probably. Why? Well, because our fairness review here is effectively showing that the opportunity did not belong to the partnership. The partnership did not have an expectation in the opportunity. It was not within the partnership's line of business. This came to me in my individual capacity and not my partnership capacity, not my official capacity. The partnership had rejected it earlier. The partnership was not able to engage in this transaction financially or otherwise. And if I take this transaction, I will not be in direct competition with the partnership. Once again, if I can use these factors, and these are not elements, I don't have to show all of them, but if I can use these factors and show the court that it was fair for me to take the opportunity, then I will probably not be liable to the partnership for the money I made in that business opportunity. What about ratification? Yes, probably. If the other partners approve me taking the business opportunity, then I will be effectively protected against any type of duty of loyalty lawsuit. Now remember, once again, this is probably an extraordinary transaction which requires approval by all of the partners. So our ratification here would require approval by all of the partners. Naturally, you may change this by partnership agreement, and a lot of partnership agreements do change this. They clearly delineate what type of opportunity you must give to the partnership and what type of opportunity you can take for yourself. Let's talk about non-competition, right? Naturally, you can change this by agreement. So what is this about? Well, partners may not compete with the partnership. The partners owe a fiduciary duty to the partnership. The partners are agents of the partnership, and an agent, any agent, is under a duty not to compete with the principal. We didn't discuss that. Our directors and officers have this same duty in the corporation, but the problem is a little bit more acute. It's a little bit more pronounced in the partnership context. So a partner cannot compete directly with the partnership. Naturally, the parties can change this by partnership agreement. Let's now talk about the duty of good faith in the partnership context. Same things, we're looking for the same things that we were looking for when we talked about the duty of good faith of officers and directors in the corporation. Did the partner have an intent to harm the partnership? If so, she was acting not in good faith. Did she consciously disregard a duty to act? If so, she was not acting in good faith. And finally, if she knowingly engaged in illegal conduct that harmed the partnership, she was not acting in good faith. There's another little wrinkle to the duty of good faith in the partnership, and that's not your duty of good faith to the partnership, but your duty of good faith to the other partners. A little bit different than what we saw in the corporation. And later, when we talk about closely held corporations, we might see that there's a similar doctrine in closely held corporations. The basic duty of good faith to your other partners is the duty not to freeze them out. And we'll talk about what that means a little bit more in the next section, where we'll deal with specifically this duty not to freeze out your partners.